Hello, everyone. My name is Cliff Davis. I'm a shareholder with Roberts Markel Weinberg Butler Haley, and today I'm going to be talking with you a little bit about nuisance animals. So I don't know if we have an hour on this, but we'll do what we can, and I'll be able to take some questions at the end, as many as time will allow. So we're going to talk a little bit, like I said today, about nuisance animals, pet issues, association strategies, and dealing with some of these issues, and some potential pitfalls. So there's all types of nuisance animals, and really kind of what we're going to focus on today is feral hogs, urban coyotes, overabundant deer, dogs and cats. Some of you may not experience some of these issues with like the hogs and the coyotes and the deer, but we'll just kind of give an overview of some of those issues and some ways to try to address those issues. And then we'll just talk about your everyday common pets and issues related with them, and deed restrictions related to those pets. We will start with feral hogs. And the belief is that feral hogs are just pigs in general, were brought by early Spanish settlers. At some point, some of these hogs were left behind or escaped into the wild and have created this giant feral hog population. And in Texas, it is a big problem. There's an estimate of 1.5 million feral hogs in Texas. You can usually tell when they're in your community. There's some of the telltale signs are wallowing, rooting, crossing trails, and an even more telltale sign is you see them everywhere. And you'll see down at the bottom, there's a link to the Texas Parks and Wildlife article on feral hogs. That's a good resource if you want to go read a little bit about them. So feral hogs are unprotected. They're non-game animals. They can be taken by any means or methods at any time of the year. There's not a hunting season, but if you're hunting and your local authorities require a license, you got to have a license and also permission of the landowner. It's funny in the Texas Parks and Wildlife article that's there, it basically says you need to kill as many of these as quickly as you can. They say it a little nicer. They talk about lethal control measures, and that's a quote from the article, are the only effective way to reduce the population of these feral hogs. One of the methods is trapping them, and they talk about dispatching after trapping them. So they're pretty clear that there's only one way to address this problem. And they talk about trapping, they talk about putting up fencing. Aerial gunning is one of the methods they talk about, which means getting in a helicopter with a gun and shooting them. And repellent, there's repellent products out there. However, according to the Texas Parks and Wildlife, they don't really work that well, the repellents. I didn't know till recently that pigs are what is called an ungulate, which means an animal with hoofs. So if you want to start off a conversation at a party, you can ask somebody if they knew that feral hogs are the most abundant free-ranging ungulate in the state of Texas. See how that goes. So the Texas Parks and Wildlife, some boards may want to call them to get help, and they will offer some guidance, but they don't take any action. This really comes down to an association issue if they're in your association, and something the board has to deal with. I've got a client out near Bryan College Station, and they have this issue, and they have hired a trapper who traps these things and then takes them away and takes them and does away with them. We can only assume. I don't think anybody really wants to know what he does with them as long as he gets rid of them. As fast as these animals can be eradicated, they breed and they're everywhere. And with housing expansion, meaning the development of subdivisions, further out into what were once considered rural areas, it creates an issue with these animals because that is where they live. So also going to talk a little bit about coyotes. And again, with this, the Texas Parks and Wildlife will give some advice, but they do not implement nuisance control. They're also an issue with the expansion into formerly rural areas. They're not as strident, Texas Parks and Wildlife, in their talk on coyotes, but kind of the underlying message is it's the same issue to deal with them as the same as with the hogs, is they have to be eliminated. You know, what Texas Parks and Wildlife recommends is don't feed coyotes, keep pets inside, keep pet foods inside, be careful with your pets. And again, this applies to really neighborhoods primarily that are out in rural areas, even though every once in a while you'll hear about a coyote that's kind of, you know, in an urban area for whatever reason has found its way there. One of the things they talk about with coyotes too is, and we're going to talk about feral cats in a minute, is not to feed feral cats because they attract coyotes, who's a predator of feral cats. You know, a lot of it with these animals, trying to keep them away from your neighborhood is just trying to use common sense. And you'll have those owners out there that are going to want to feed these animals, which is just not a good idea. We can talk about some ways to address that. Overabundant deer is also a problem. You know, deer's a little different. Obviously, there's a hunting season for deer. And that hunting season, one of the reasons is it's according to Texas Parks and Wildlife, provides a social benefit. It also provides control of these animals. There was a time when the population of deer in Texas was almost eradicated, but the state entities implemented some programs to bring them back. And now it's just a matter of trying to keep that population under control. You know, and the problem when you start developing into these neighborhoods is that, and there's an overabundance of deer, is that it leads to collisions, which I think they estimate between 5 and 10 people die a year from a collision with a deer in a vehicle, or a buck that's aggressive, which typically deer are not an aggressive animal. So, you know, you've got to be careful in your neighborhood how you're going to handle these deer problems. There may be hunting and firearm restrictions. There's some things you can do in your restrictions to address them. And it's some of the same issues that you have with these other animals is if your restrictions may have a language in there about feeding wild animals or feral hogs or urban coyotes, of trying not to create an attraction to those animals to come into the property. And some of that can be done through some rules and regulations. If you don't have language in your deed restriction, what you would need to do is talk to your attorney to review your restrictions, or if you don't see anything in there, talk to your attorney about maybe if you've got some authority to adopt some rules and policies to try to address some of these. And again, the Texas Parks and Wildlife has some management options: hunting, sharpshooting, which there are programs where you can hire, in fact, I guess, deer sniper to come and try to reduce that population. Relocating is another tactic that you can use. Predatory reintroduction is not recommended by Texas Parks and Wildlife, because that would mean bringing in, you know, larger animals, which would just creates another type of problem. And again, some of the things we talked about is try to encourage no feeding. There's fencing options you can use to keep them out of your neighborhood. You look at your plant life, and maybe for your landscaping, if you're in one of these kind of country or rural neighborhoods, is to talk with an expert about what type of landscaping and plants will not attract deer. Deer repellents, I think, work a little bit better than repellents for the other animals we've talked about. So those are options out there too. And again, at the bottom of this slide, there's a link to a Texas Parks and Wildlife that discusses all of these issues. So most of you probably just have problems, not with any of those animals we talked about, but with just cats and dogs. And generally the first thing you want to look at when you have any problem, including a pet problem, is to look at your declaration and see what does it say about pets. And there's a sample in here of a pet restriction. And sometimes they will limit the number of pets, you know, to 2, or you know, this one says a reasonable number of cats and dogs, which obviously that raises an issue of what is a reasonable number. So you need to look to your restrictions. The issue that we see a lot is somebody will have some aggressive dogs, and they'll have 4 or 5 of them, and we look at the restrictions and it'll say you can have 2 pets. Well, the problem with that is enforcement. Are you enforcing that restriction? My experience is that a lot of times that's not a restriction that's being enforced until it becomes a problem with an owner that has animals and doesn't maintain those animals, doesn't control them, or they might be aggressive. So you've really got to look to your restrictions, make sure you understand what they are, and determine if you're enforcing those restrictions consistently. If you're not, you need to think about amending your restrictions so that you don't face a problem where you fail to enforce it and therefore lose the right to enforce it at a later date. But that's the first thing you want to look to. And then obviously, the restrictions like in this one, a reasonable number, this limits it to a reasonable number of cats, dogs, or other generally recognized household pets. If you've got something like that where it's not crystal clear what that number might be or what is a generally recognized household pet, you can think about adopting a policy that kind of fleshes this out a little more and gives owners more information so that when you go to enforce a restriction and you say, well, the number of pets you have is not reasonable, they're going to say, well, to you it might not be, but to me it's reasonable. If you can point to a policy that is in writing and filed and say, the restrictions say this and the policy defines that further. Just really in general, anytime you're enforcing a restriction that might be somewhat vague and you need to crystallize that a little more, it's a good idea to adopt a policy, because otherwise owners think you're making it up as you go along. But if you can point to a policy that fleshes these types of things out, it's something in writing, it'd be filed with the county, and it's reasonable. You can take the reasonable position that you're going to enforce your policy that further expands and clarifies your restrictions. And of course, we've got some pre-submitted questions, and a lot of those involve the barking dog. And a lot of older restrictions don't specifically address this issue. And even when they do, it becomes an enforcement issue. Is you've got one neighbor calling saying, hey, my neighbor's dog barks all the time, I want you to do something about it. So the question is that really a nuisance to the community, or is that an issue between those two neighbors? And generally our advice is, if you've got one person complaining, that's a neighbor to neighbor dispute that they need to resolve between themselves. Because when you come up with this type of a complaint from a neighbor, really associations, you want to try to avoid becoming involved in this, because it's a no-win situation for you. You've got the one neighbor complaining about a dog barking, and the dog owner, is going to say, well, the dog doesn't bark that much, or they're overly sensitive, or dogs bark every once in a while. And you go back to the other neighbor and they're still saying, you have to do something about this. So really what you want to look at with barking dogs in general is how many people are complaining about it, how many does it affect. If you've got a pet limitation restriction, you can look and see if the person with the barking dogs has 6 dogs on their property when the restrictions limit it to 2, and that might be an avenue to try to address the problem. But again, you face that, have you been enforcing that against other people in the neighborhood that have more than 2 pets? But generally with barking dog complaints, if you do have a number of neighbors complaining, it becomes, how do you prove this? And the only way to prove this type of violation is for the neighbors to be willing to testify and to be willing to keep, like a log of date, time, and what they're hearing, recordings if possible. Nuisance provisions are when you're pursuing something on a nuisance provision, obviously the board's not there to see it for the most part. The property manager can't be there to see it. It takes neighbor involvement, and a lot of times they don't want to get involved. So if you go down the road of pursuing a noise issue or a barking dog issue that's affecting more than one owner, you want to tell these people up front is you're going to have to be willing, if necessary, to come to court and testify and stand, 3 feet away from your neighbor and say, his dog barks, here's the recording, this is the problem, I've got children that can't sleep. And a lot of owners don't want to have that level of involvement, but there is simply no way to really prove this type without neighbor involvement and without details of when and how this happens. And typically the neighbor involvement, you want non-board member complaint witnesses. So the judges, they'll take a non-involved witness. Their word carries a little more weight than a board member coming in and saying, yeah, that dog barks all the time. So just keep that in mind with in the end, the owners are the people that live there, and they have to be active in enforcing the restrictions in cases like this, where you can't just drive by and take a picture. So there are some restrictions that have breed restrictions in there, which the case law says you can do that. You know, you get a lot of people that have dogs that say there's really not inherently an aggressive animal, but there are a lot of associations that they don't want pit bulls or Rottweilers or those aggressive type of animals, and their solution has been to ban those breeds. And it becomes it's an issue because obviously people don't want to give up their pet. And if you try to amend your restrictions to do that, it becomes a question of, can you go back now and make it kind of retroactive to the people that already had those animals? My guess is that's probably likely not going to happen. That a court won't make somebody get rid of a dog if it was okay to have that dog before the restrictions were amended. So feral cats is also another problem. Apparently it's widespread through San Antonio, but I know I'm here in our Houston office and I get complaints about these too. And the biggest problem with feral cats are the owners that feed them. And again, we talked about that a little bit earlier. And you really want to discourage that from happening, either through restrictions in your declaration or through a policy or a rule that makes it a violation to feed these types of animals. According to Texas Parks and Wildlife, feral cats are more than twice, rabies is more than twice as common in cats as in dogs. So they are a health threat. You've got to be careful with these things. But again, the answer here is to try to address it through rules and regulations that you can enforce. And those all need to be in writing. If it's not directly in your deed restrictions, in your declaration, you need to talk with your attorney about your authority to adopt a separate freestanding policy or rule that you can then enforce as with any other type of deed restriction. Again, what we talked about: do not feed, trap, neuter, and release programs. Generally, Texas Parks and Wildlife doesn't believe those things work with these feral type animals. Really the solution on most of these is the elimination of these animals. And again, there's a site down at the bottom of that slide that will give you some more information and a little more detailed information on the issues that these animals raise in communities. And again, what we talked about is a way to address these is to amend your restrictions if you can. Believe me, all attorneys understand how difficult it is to amend a declaration, and that's even if you're trying to do something that is really widely supported. We know that it's a lot of work. Ultimately, amending deed restrictions will usually come down to knocking on doors to try to get those signatures. But if you've got a good issue and you've got community support, that's something you might be able to do. And what I always tell boards is that they call and say, we want to amend our restrictions to do this. And I always tell them, look, if before you spend the first penny in attorney fees, you need to go into your community and make sure that you've got support for this, because it is a difficult process. It's difficult to get people to sign any amendment, especially if the problem is something that they don't see every day. So before you want to spend money on amending restrictions, you should make sure you've got some support in the community. And you can do that by, surveys or trying to have town halls or newsletter articles to try to gauge what's out there and how everybody feels about something you might want to address through an amendment, whether it be animal or any other thing. If you don't think you can amend your restrictions, that's not an option for you, then you should consider, like we talked about, adopting some rules or regulations or guidelines that specifically address the issue in your community. And then we put in a little sample of a provision there that you could put in a guideline or a rule. And again, community outreach is the key when you're trying to address these issues, to see what kind of support you have, and there's the various ways to try to get community support when you're going to try to address these issues. Sometimes it's a no-brainer. The people are coming to you demanding some action, but sometimes it's one portion of the community may not realize what other owners in the community are going through, and you might need to try to educate everybody on the problem, and then talk with them on what the fix would be, whether it be an amendment to the deed restrictions or adopting some rules. One of the issues with anytime you want to deal with your animals is that you're going to have owners who don't want the animals hurt or eliminated in any fashion. And that's a problem. And what you can do with those owners is, again, try to educate them on the issues with these wild animals, especially like feral cats, feral hogs, that there's no benefit to those type of animals, and they can do a lot of destruction. So you've got to keep in mind that there will be people out there that will be against any program to eliminate these animals. You've got to look at a cost benefit analysis, as how much is the association willing to pay to address this problem. My understanding is these people that trap or kill hogs, sometimes it's a fee per animal that they'll charge you for what they kill. Obviously, if the cost is enough, they might have to take a special assessment, which most owners don't like to hear that word. So you just got to be careful about how you address this. And again, the key to that is education within the community and getting the support of the community. And then for the end, we put up some pictures of cute animals, because who doesn't like a picture of a cute animal? So we'll answer some of the questions. And I've got a couple pre-submitted, and then I see some people are typing in. You can type in a question if you have, using the Q&A function at the bottom of the screen. And we'll go ahead and start with this. The biggest nuisance we've come across with animals is defecation on neighbors' lawn or common areas. Is this something that can be enforced? And if so, how? So, the first thing you have to keep in mind is the association's authority is to enforce its governing documents. So when you get a complaint about a problem, the first thing you need to do is that something that we can address? Is it prohibited in the governing documents? Do our governing documents give us authority to address it? And if not, it may not be something that the association can do anything about. The board's not there to remedy every wrong that an owner feels. So on this type of issue, in order to take any action, you'd have to see does our declaration, our deed restrictions, or do we have any rules or guidelines that prohibit owners allowing their animals to defecate on neighbors' yards? If you do, it's just treated like a deed restriction violation. So you would send your normal series of letters, whatever that may be. Some send, 1 or 2, some send 5. And that series would typically end with your 209 violation letter that contains the statutory language required by Chapter 209 of the Property Code. And then you could turn that over to your attorney to send demand letters and file a lawsuit if necessary. So what a lawsuit on something like that would look like is you would ask the court to order the owner of the dog to stop violating the restrictions, to stop allowing their dog to defecate on other people's yards. So the answer is yes, it can be enforced if you have a deed restriction or a rule that prohibits that type of behavior from animals. This next question is, excuse me. Can the association require, as part of the board's sole discretion of nuisance claims, that an owner work with a trainer to help a dog acclimate to its new yard? So I think what's happening here is some restrictions gives the board the sole discretion to determine what is a nuisance. I don't think that authority would give you that if you've got that in your restrictions where the board has the sole authority to determine what constitutes a nuisance, I don't think you can extrapolate that to mean that you can order an owner to work with a trainer. All you can do is address the nuisance itself. Let's see what else we have here. How much discretion does the board have over nuisance claims? That's something where if you've got authority, the board has the authority to declare what's a nuisance. That would be enough, I think, for you to adopt a policy saying, we will consider these activities or behaviors nuisances. One of those could be, dogs defecating in a yard, dogs not walked on a leash, or aggressive dogs not walked on a leash. So if you've got that authority, it kind of gives you a door, an opening to adopt some rules to state what would constitute a nuisance. And you could, include some of these pet behaviors that may not be more specifically addressed in your declaration. If a homeowner states they have removed the nuisance animal from the property, but complaints are still coming in, how can we verify the animal is gone if the neighbors do not want to provide pictures? Well, again, that's when you have to go to the neighbors and say that, we can't do this for you. This is something that is affecting you and the people that live around this animal, and you have to become involved. We can't be the bad guy for you because we don't see it like you see it. We're not there. You've got to educate these people that on this type of complaint, they will have to be involved. And, a lot of people say, well, I don't want my name given out if the owner asks, because when you send a letter to an owner on something like this, they'll say, well, who, I want to know who told on me. What I advise boards when that happens is say, you can tell them we're not going to give you the complainant's name. And you can tell the complaining neighbor that we will not give up your name. However, if a lawsuit is filed, you cannot keep that a secret. That will come out, and the complaining neighbor should be told that is, we will not, give up that you made this complaint unless and until we are required to do so by law. And if a lawsuit gets filed or there's legal action, if the owner files a lawsuit and they send some discovery, that says basically, give us a copy of every written complaint you've received about this, or tell us who the complainants are, you're going to have to tell them. You can't keep that a secret. So really the answer to the question is there's no way for you to verify it, unless you happen to drive by the property as the property manager or board member and you see the animal out there that's supposed to be removed from the neighborhood. Let's see, pets not on a leash, not abiding Montgomery County law, have been ticketed several times. How does a POA handle this situation? Well, again, this goes back to what do your governing documents say? A lot of them won't say that you have the authority. I mean, associations don't have the authority to enforce the law. That's law enforcement. So if the only issue here is that they're not abiding by a governmental leash law, the remedy you have is to contact the governmental authority and try to get them to take action, which we all know can be difficult at best to get the government sometimes to take action. But if they're also violating a restriction, you've got the process we talked about before, where you just handle it like a deed restriction violation, go through your process, turn it over to the attorney if that's what the board wants to do, and ultimately file a lawsuit. And then there's one question here. It just says roosters. Generally, most restrictions ban poultry from neighborhoods, which would include roosters and non-roosters. Every legislative session, we get a lot of questions where some owner will claim that a law got passed that protects roosters. That is not the case. There is one every year out there. It's every session out there that seems like that wants to limit an association's ability to prohibit roosters. None of those protections have passed as far as I know. So if you've got a restriction that prohibits poultry, you can address that and write violation letters on chickens and or roosters. What is the best way to mediate neighbors affected by another neighbor's barking dog? We talked about that a little bit. Generally you want to run away from those. Don't walk if it's just between two neighbors. If you try to mediate that, a lot of times, like I said, it's just going to be a no-win position for you. But if you get complaints by multiple neighbors, that's when you may decide, hey, we're going to send a letter because we've got 3 people complaining, not just one. And then you just have to kind of, it'll be a use your best judgment on how far you want to take that. So it looks like we've got some questions also that have been typed in. Can you talk about nutria rats as well? My guess is that those are probably the same as a feral hog or a feral cat, and that elimination is probably the way that to handle those. Again, if somebody is, if you've got an owner that is doing something on their property that's attracting those animals, then you need to see if you can address that through either your declaration or rules that prohibit any type of behavior from an owner that would attract those animals. Ducks, I think it's the same thing. I know that there's a lot of association with lakes, and ducks can be a problem on those lakes. And probably the best way is if you have a lake company, they may be able to remove those for you. Or I know that in one association I had, they found a contractor that would come and take the ducks away. And I think he actually didn't eliminate them. He had somewhere where he could take those. Also, what to do when an activist send out a petition and put your information out on an email and phone number. That's, I think, a question without an answer. I don't know how much you can do about that. That's probably something you might want to talk with your personal attorney on it. I mean, we have written letters here and there over the years and to tell people to stop, but if they have it and they're putting out information you prefer they not, it really becomes an issue of what private cause of action you would have against that person for exposing that information. What can be done for, and this is back to ducks, what can be done for overpopulation in the community and residents feeding them? Again, you need to try to address the resident feeding through rules. Probably going to be difficult to prove, but it's something that's really the only option the association has is adopt a rule or amend the restrictions to prohibit it, and then work to get the evidence to prove who is doing it and pursue them as you would any other deed restriction violation. When the next question, when the city comes to address feral cats, but then provides the party causing the issue with an application for a licensed feral cat colony, how do we counteract this? How long do we have to wait before picking up the complaint again because the city is involved? I am not aware of a licensed feral cat colony, or that was even a thing. I think this would probably take some research by your attorney into the ordinances behind that provide support for a feral cat colony. I think this would take some digging down. I don't really know the answer to this off the top of my head. But again, even if the city has a license for something, if you've got a declaration or rule that prohibits, that's not going to override that declaration or rule. You can still enforce your documents against the feral cat thing. The city can't come in and excuse someone from violating the deed restrictions. What would you say to a homeowner and how to submit violation to homeowner about the smell of a chicken coop? I have heard this complaint before, and obviously the first thing you want to do is see if your restrictions prohibit chickens. If they do, you've got that. If they don't, and you've got multiple neighbors complaining about the smell, and you have a nuisance provision, that might be your avenue to pursue that, is that it's a nuisance to these people and it's a nuisance to more than one. If it's just the one neighbor complaining, my response to that is that's between you and your neighbor, and you're going to have to deal with that on your own. And something that you can remind complaining neighbors who want you to enforce some deed restriction where the board might think, well, that's not really a violation, or it doesn't rise to the level where we think we should get involved, is remind every owner that they have the exact same legal rights to enforce deed restrictions as the association. I mean, obviously an owner can't collect assessments. But for any use type restrictions, every owner is in the same shoes as the board of directors with regard to their rights to pursue a violation. They can file a suit. They can do whatever they think they need to do. And sometimes that's just the situation where maybe that's a violation, maybe it's not, but we're not going to pursue it. But you feel free, and you've got the same rights as we do. This is a long one. 2 dogs running loose and aggressive to walker-bys. There was a letter sent, and then last night someone was bitten, and the board is considering attorney action. Again, you need to see what your deed restrictions say about animals and aggressive dogs. There is I imagine I'm in Harris County, and I know that Harris County has a procedure where if there's an aggressive dog that bites someone, there's a process you can go through with the justice courts to have that dog declared an aggressive animal. If a judge agrees with that, they will take the animal away from the owner and require certain things from the owner before they'll give the dog back. And in some cases, if the owner doesn't do what they're supposed to, they'll euthanize the dog or the whatever the animal is. That's going to be much more effective in a lot of cases than what the association can do. Because again, the association is limited to what is in its governing documents. And so you have to see what those say and see what kind of authority you have to address aggressive animals. What about chickens in Texas? I have a homeowner complaining of a chicken coop in the backyard of their neighbor. I just need to tell them they need to be willing to send a picture or testify. I would tell them that they need to be willing to send a picture and testify if necessary. So if you've got a prohibition against chickens and somebody has one, obviously you're going to have to prove that if you pursue it. And so that complaining neighbor is going to have to be willing to be the person that helps you prove that case. If they're not, and you can't prove it otherwise, then there's really nothing the association can do about it. If a news or magazine article was printed and distributed with only interview from an activist within a community and included complete inaccuracies, which defames any individual on a board or management team, what measure or actions can or should be taken? So, with social media, you don't even need a magazine anymore. People can just put stuff out there. And, generally we advise boards not to get in a back and forth on social media. But if you become aware of inaccuracies out there, your response can be to put out factual information. And that would be through your newsletter, through an email blast, through a mailing, whatever it takes, and you want to keep it kind of as direct as you can and say, and start off, it's our understanding that there is information being spread in the neighborhood that blank, here are the facts, and then lay out the facts. That's really the only way you can kind of counteract that. Again, nobody has ever won an argument on social media, so there's no use getting in that back and forth. But if you try to put out information through association sources, mail, newsletter, on your website, and try to address all of those things factually. With regard to defamation, defamation is a personal cause of action. It's not really an association cause of action. Now, having said that, we have written letters that warn someone that, what they're doing may rise to the level of defamation or is defamatory, and that they can be pursued legally for that. So that's something where if you think it's defamatory, you need to give it to your attorney and ask them an opinion on that and what options there are. A lot of times a board will say that this person's defaming. One board member will complain that they're being defamed, and when we see it, it's not really defamation. It's not nice and it's rude, but that doesn't necessarily rise to the level of defamation. Boards need to have thick skins because there are going to be people that say bad things about them and mean things about them, and it will be on social media. In most cases, the people that are doing that on social media, it's kind of an echo chamber where it's that small group, and they're the only ones that are watching that on social media. So it's not necessarily spread throughout the neighborhood, but we have seen that where it becomes an issue within the community. And in that case, our suggestion is that you put out factual information. Let's see, homeowner complains about people walking dogs without a leash. Constable says they can issue a ticket, but it's the deputy's discretion. And usually they won't issue a citation. And yes, that is true. You know, a lot of things like this, it's in the discretion of officers and they don't necessarily want to do that. Um, they don't want to write tickets for things like a dog not on a leash. If that becomes an issue, the only thing really you can do is try to get to that person's superior and explain to them why that's an issue, why a citation should be issued, and try to get their captain or whoever's above them, you know, to understand that it is a problem and why that their officers should issue those citations. But ultimately, that is an officer's discretion type of thing. Owners feeding squirrels. Any thoughts on bird feeders? You know, if that's a problem, it's again, is what do you have in your documents that prohibits that, and do you need to think about that if that's becoming a problem? You know, we've had a case once where this lady was feeding some type of bird, and we got pictures from her neighbors where there were literally hundreds of birds sitting on top of her roof waiting to be fed, and that was creating an issue because you know what birds do when they eat, and the neighbors were complaining about that. And they had some language in there that we could use to support a violation, and we wrote that letter, and ultimately we got it stopped. My colleague in San Antonio says that the city of San Antonio has a licensed feral cat colony ordinance. So I think that his name is Brady Ortego. He is the expert on feral cat colony ordinances. He's in our San Antonio office. You can contact him directly to handle any of those. What would your recommendation be for alligator issues? Would the HOA be responsible to get these removed? I guess it really depends. You know, are the alligators on lakes or property owned by the association? If so, the association may have some obligation to take steps to remove the alligators. Again, that's something I would definitely talk with your attorney about and see what options you have or what your attorney believes your liabilities may be. Someone is pointing out that CAPS in Houston has a good website on feral cats. Did a new law pass? We have to allow chickens in gardens? Well, gardens you have to allow. Chickens, there's not a new law. That's got to be a typo. Chickens and something else, perhaps roosters. But no, there is no law that protects them. If you've got a restriction that says you can't have a chicken, then you can't have a chicken. Chickens are not allowed in our neighborhood, but we have a family that has two because they have a letter from a board certified doctor that the two chickens are emotional support animals. So we have to allow them in that instance. So yes, that is an issue of emotional support animals. There's been some recent changes to that about what type of animals, and I'd have to look into that further. But I would definitely, if you've got somebody that wants some odd animal and claiming it's an emotional support animal, to talk to your attorney to see what regulations there are out there about the type of animals that can qualify as emotional support. So again, this is an exception. There's an exception to everything, and a lot of people have been abusing these emotional support animals to try to justify some weird animal that they want to keep at their house. What if you have two large dogs that come in through the entrance of the community and they cannot be caught? However, we have seen them, but the ASPCPA cannot catch them. Is the HOA liable? You know, probably not. You really can't control free roaming animals if they bite somebody or something and they're not yours. So I would say that you probably don't have any. So the last question we won't answer because it's inappropriate, also from my colleague in San Antonio. I don't see any more out there. I am hoping that you got some good information today. The takeaway today is always check your documents for any type of issue to see what is in your documents that you can enforce. And if you've got some animal issue that you can't, there's nothing specific in your documents, then you should talk to your attorney about your authority to adopt guidelines and rules and put those in place to try to address whatever your issue is. And once you have a provision that prohibits any activity or behavior, the remedy is to enforce it like you would any other deed restriction matter. So thanks for attending today. This one was a little shorter than a lot of times than a lot of them, but hopefully we covered all your questions, and thanks for attending.